Thank you all so much for being here. My name is Katie Naples Mitchell. I'm the program director of the Program in Criminal Justice Policy and Management, Harvard Kennedy School's Malcolm Weiner Center for Social Policy. This is the sixth session of our speaker series this fall on criminal law as a tool of authoritarian control. If you missed the first 5 sessions, those videos are now available online on our YouTube channel, which I'm dropping a link to in the chat. And you can read about the speakers and access any links that were mentioned or articles that were shared on the individual event pages, which you can get to from that link on our website to the whole series. We have one more event after this week, next after Thanksgiving. It is on December 3rd with Jennifer Pan of Stanford to talk about criminalization and political repression in China. And I'm just going to go over a couple of general notes about how we run this series. As you all know, we are running this fall as a webinar. We are encouraging continued audience engagement, nevertheless, and we would want to make sure you know that there will be about 15 to 20 minutes for questions from the audience at the end of our moderated conversation. To ask a question this week, please drop your question in the Q&A function of the Zoom. We're going to try to keep a running queue there. I will screen the questions in advance and then invite speakers to unmute in the order in which the questions were submitted. So thank you so much in advance for being able to do that. And if you have links or resources to share, you can also drop them there in that Q&A, and I'll make sure they get shared out into the chat from there. I think that's all of the housekeeping that we need to do. So in order to move us into the conversation, I'm going to introduce our two wonderful speakers. Azadeh Shahshahani is the Legal and Advocacy Director of Project South, where she advances a practice of movement lawyering focused on confronting state repression and dismantling systems of surveillance, incarceration, and deportation. Azadeh has organized for 2 decades to protect and defend migrants and Black and Muslim communities from systemic Islamophobia, xenophobia, and anti-Black racism. She also provides support to social justice movements in the global South, from Brazil to Palestine, and is a past president of the National Lawyers Guild. She currently serves on the Advisory Council of the American Association of Jurists and is the author and editor of several groundbreaking human rights reports, as well as law review articles and book chapters focused on movement lawyering, immigrants' rights, surveillance of Muslim Americans, and using the international human rights framework as a tool for liberation. Thank you and welcome, Azadeh.
Thank you.
And our second speaker, in no particular order, is Raqib Naik, who is the Executive Director of the Center for the Study of Organized Hate, a research and policy organization based in Washington, D.C. Previously, Raqib founded hate tracker HindutvaWatch.org, a real-time data set of human rights abuses, and India Hate Lab, which studies hate speech targeting India's religious minorities in the digital and offline realms. He also serves as a fellow at Bard College's Human Rights Project and at the Political Conflict, Gender, and People's Rights Initiative at the University of California, Berkeley. Welcome, Raqib. Thank you so much for being here. So to kick us off today, we often like to start by kind of defining terms, and one of the terms in our title for today's event is counterterrorism, which is a loaded term that can have lots of definitions to different people. So I figured we would start with understanding from each of you, how do you define and what does counterterrorism mean to you? Is it a political ideology, a set of logics, a set of policies and laws, and what might those entail in some of the contexts you have studied? How is it defined under international law, and how does the international human rights regime respond? Azadeh, maybe you can kick us off and then we'll come to Raqib.
Thank you very much, and thank you, Katie, for the kind introductions. It's a great honor to be here and also to share this platform with Raqib this evening. So across the world, governments use the same tactics to repress dissent and dismantle social justice movements. These so-called counterterrorism frameworks are used by governments to inhibit movements for social change. Governments silence dissent and human rights concerns by weaponizing the regulations that were purportedly created to provide protection from terrorism. International standards mandated and continue to influence the creation and implementation of national counterterrorism laws. So following the launch of the so-called war on terror, U.S. national security frameworks were exported globally with the support of the UN. In September 2001, the UN Security Council adopted Resolution 1373, requiring states to suppress the financing, support, and commission of terrorism. It also created the Counterterrorism Committee to monitor implementation of the resolution. Within 2 years, all 191 member states submitted initial reports to the committee, outlining steps taken to implement Resolution 1373. And many countries adopted counterterrorism measures in line with Resolution 1373. G7 leaders originally established the Financial Action Task Force in 1989 to counter money laundering. Within a year, it issued 40 recommendations. In 2001, the task force expanded its mandate to include counterterrorism, and by 2004, it issued 9 special recommendations. The task force's so-called 40 plus 9 recommendations set an international framework to combat terrorism and money laundering, which the task force encourages countries to codify in domestic law. Although the task force does not create binding regulations, many member states opt to comply to avoid economic consequences. And the task force's recommendation 8 is particularly misused by governments to justify crackdowns on civil society. The recommendation calls for, quote, focused, proportionate, and risk-based measures to protect nonprofit organizations from terrorist financing abuse. But instead, governments have used it to target human rights organizations critical of governmental actions. And although Recommendation 8 has received significant attention, numerous other task force recommendations have also been weaponized by governments. And on the domestic front, often domestic counterterrorism regulations contain vague, overbroad, and varying definitions, and government officials may refer to extremism and terrorism interchangeably. This lack of clarity often results in a chilling effect on civil and human rights advocacy, as organizations and individuals fear prosecution and reputational harm associated with being construed as supporting terrorism. This is most evident when humanitarian actions such as charitable giving are labeled as so-called material support to terrorism, or when activists are labeled or targeted as so-called terrorists or extremists for simply expressing views critical of the government. This government repression also serves to stigmatize and financially marginalize organizations and human rights activists. Terrorism has been broadly used to justify the suppression, surveillance, and targeting of human rights organizations, and in many cases, the precise definition is tied to the will or intent of the authority wielding it. Meanwhile, UN experts have maintained that counterterrorism efforts must be enacted and applied in accordance with international human rights obligations. So the right to freedom of expression and association are fundamental human rights affirmed in the International Covenant on Civil and Political Rights, also known as ICCPR. The treaty is binding on the 173 state parties that have ratified it, meaning that they are obligated to comply with its requirements. Most relevant here, the US and Israel have both signed and ratified the ICCPR, while India is bound by accession to the treaty. Article 19, Section 2 of the ICCPR provides the right to freedom of expression, while Article 22 guarantees the right to freedom of association. And the right to freedom of expression includes political, human rights, and religious discourse. The UN Special Rapporteur on the right to freedom of peaceful assembly and of association clarified that the right to access financial and other resources is inherent in the right to freedom of association. And other international human rights bodies have confirmed that the freedom to carry out activities, including receiving funds, is crucial to the right to freedom of association. Unfortunately, counterterrorism laws often violate these foundational rights.
Thank you for that overview. Raqib, I don't know if you have anything you want to add. We've got a comprehensive picture of sort of some of the legal underpinnings, but I think there's more to say. Go ahead.
Right. Thank you so much for having us speak on this extremely important topic. And I think the first thing we need to acknowledge is that counterterrorism is not a neutral concept. It is often represented as a coherent set of policies designed to keep people safe, but in most of the contexts, including in South Asia, the region I'm going to talk about today, counterterrorism is and has fundamentally been a political project. It has kind of, become a way and means of defining who belongs, who is a suspect, and who can be subjected to the extraordinary forms of state power with very little accountability. And as Azadeh mentioned, internationally, counterterrorism is defined under a patchwork of treaties and UN Security Council resolutions, but there is no universally agreed upon definition of terrorism, and that ambiguity gives states enormous discretion which many, including in South Asia, the governments use to expand the definition to encompass activism, human rights work, even humanitarian work, the groups that are involved in it that the state disfavors. And international human rights law, as again Azadeh mentioned in theory, imposes limits, whether be it proportionality, due process, freedom of expression, and prohibition of arbitrary detention. But in practice, international mechanisms have been too weak to restrain these very powerful government that invoke the national security paradigm. So, what I have seen personally as a Kashmiri who was forced into exile, and as someone who now documents that patterns across South Asia, especially India, is that counterterrorism has become a way to govern minorities, whether be it Muslims, be Dalits, be Christians, be Sikhs, or Kashmiris, or journalists, or student activists and human rights defenders. They all can be or labeled as potential threats. And once they're placed within that category, that state can then justify surveillance, raids, asset freezes, arrests, travel bans, including one that has been imposed on me. I cannot go back. I've been put on a no-fly list, lookout circular, all for my advocacy for human rights and doing work documenting hate crimes and hate speeches in the country. Um, and all of this is kind of being done under this language of counterterrorism, and it has become very normalized. So counterterrorism is essentially an ideological framework that constructs certain communities as inherently dangerous, and it is kind of become a mode of governance that erodes these democratic rights while claiming to protect the safety of the people and to protect the nation.
Thank you so much for offering that perfect complement to the sort of legal framework that Azadeh shared, right? I think your answers together give us a picture, right, of that it is both, in thinking about this term, it is undefined, right? It is mutable for political ends, and there is a legal framework, but there's conflict in different overlapping international regimes and domestic regimes, and so that enables the kinds of oppression we're gonna dig deeper into in our next set of questions. So before we move on, I'm just going to share out an article by Azadeh and a co-author that I think is going to ground some of our next parts of the conversation, so folks can dig into that more deeply afterwards. But let's talk about the particular moment of post 9/11 and sort of the naming of the quote so-called war on terror. Azadeh, you've written about how the sort of globalization of the war on terror inspired a particular strain of kind of counterterrorism measures in the U.S. And I for kind of keying into our questions here about thinking about criminalization specifically in relation to this, I wonder if we could talk a little bit about whether that wave of legal changes resulted in sort of a commensurate expansion of prosecutions and arrests and detention, and how individual states within the United States also adopted measures that kind of changed their legal framework, in addition to some of the kind of more prominent acts that people may know about more generally at the federal level. And in particular, I think your research suggests that this was nominally rejecting anti-democratic moves abroad and dictatorial regimes and abusive state practices, but ultimately resulting in political ends and sort of that being used as a pretext in the US. So can you talk to us a little bit about that legal framework and how we should understand it in the context of our multiracial democracy?
Sure. So two U.S. statutes, 18 U.S.C. Section 2339A and 2339B, which criminalize so-called material support to terrorism, gained notoriety at the outset of the war on terror due to their prevalence in targeting Muslim and Palestinian groups. Congress enacted these material support statutes in the 1990s and has amended them multiple times, including through the USA Patriot Act and the Intelligence Reform and Terrorism Prevention Act of 2004. Section 2339A targets those who provide material support or resources for any offense identified as a federal crime of terrorism and carries a sentence of up to 15 years. Section 2339B applies to those who provide material support or resources to a foreign terrorist organization, quote, and carries a sentence of up to 20 years. So-called foreign terrorist organization, as defined by the US government, is designed by the US Secretary of State, and while organizations are permitted to challenge the designation, defendants charged under Section 2339B may not. Courts have understood material support statutes to cover support beyond simply providing supplies or money. The US Supreme Court upheld the constitutionality of these material support statutes, even if applied against those who provide human rights and conflict resolution training. And in terms of the states, over 30 states in the US have also passed their own domestic terrorism laws, many of which are overbroad and or vague. In 2017, Georgia enacted an updated domestic terrorism statute, partially in response to a 2015 white supremacist shooting that killed 9 people at a historic Black church in Charleston, South Carolina. The statute defines domestic terrorism broadly to include acts intended to disable a so-called public transportation system when such disability or destruction results in major economic loss, as well as acts intended to alter government policy, quote, by intimidation or coercion. At the bill's passage, critics highlighted the provision of the bill, which targeted the critical infrastructure, regardless of whether it is virtual or remote, publicly or privately owned, as having the potential to criminalize protest activity, such as shutting down a portion of a major highway. Supporters of the bill claimed that it would not encompass peaceful protest, and 2 state senators attempted to address these concerns by adding a provision clarifying the act shall not be construed to infringe upon constitutionally protected speech or assembly. Despite this change, as I will hopefully discuss later, the law was later used to charge peaceful protesters in Atlanta, Georgia. Material support statutes, terrorism designations, and counterterrorism statutes have had a chilling effect on social justice movements. Many of these statutes restrict the rights to freedom of expression and association as enshrined in the ICCPR, and they violate international law. And the laws discussed here are only a few examples of instances where counterterrorism laws were used against organizations or individuals in an attempt to dismantle broader social justice movements. These instances provide examples of how government repression targeting mutual aid, humanitarian aid, and human rights organizations and organizers through counterterrorism laws can be used to silence, surveil, and prosecute dissent. And it is important to acknowledge the role of the US government in exporting a counterterrorism regime that has deep impacts for organizers worldwide. Advocates have documented the influence and proliferation of US counterterrorism policy in conjunction with the so-called war on terror, noting that it has had significant repercussions both domestically and internationally. One consequence of the war on terror has been its impact on civic space, as states use counterterrorism regulations to silence human rights defenders and organizations that challenge state oppression.
Thank you for that. I think the dialogic federalism component of this, right, the kind of modeling that you're talking about, both globally and then for individual states in the US, is super important to understand, because I think there can be an information gap sometimes in thinking about the ways that these charges get leveled against people within the context of general state prosecutions. And I know we're going to talk about that in more depth shortly, but that there's often in the national security state a lot of posturing about this being a federal issue, and yet it's being kind of pulled into more local contexts. So thank you for giving us some of that history. And speaking of local context, I think we'll stay for a minute with sort of the long tail of kind of Islamophobic counterterrorism frameworks. And Raqib, you've just issued this report on through your work for the Center for the Study of Organized Hate about Islamophobic and xenophobic narratives in the New York City mayoral election. And I wonder if you could give us a little bit of context about that report and sort of the use of the word terrorist as a derogatory epithet in the context of that political fight. What are some of the kind of benefits and powers that you see as being associated with naming a disfavored opponent as a terrorist? And what does this reveal about the kind of continued currency of counterterrorism and sort of stoking social and cultural dynamics and kind of shaping or undermining democratic engagement?
Right. The research you're referring to is the report we released earlier this month, documenting the scale and intensity of online Islamophobic and xenophobic discourse around the New York City mayoral campaign between the day of primary, June 24th, and October 31st. And in that period, we identified over 35,000 posts, original posts from almost 18,000 X accounts. These are the posts and accounts that promoted deeply Islamophobic and xenophobic narratives targeting Mamdani and more broadly the Muslim community. And these posts generated almost 1.5 billion impressions. And one of the most striking findings was the central role of the verified users, so-called blue badge accounts on X, and nearly 4 in 10 in total accounts spreading this harmful content were these blue badge users. And I think um, the the volume of harmful narratives intensified quite dramatically as the election approached, because October alone accounted for almost 43% of the total posts, which is kind of a 450% jump from September. And when we digged in deeper and tried to do thematic analysis, it showed that the extremist and terrorist labeling was was by far the most dominant narrative, comprising of almost 72% of all the 35,000 posts. So in these posts, we repeatedly saw Mamdani and more broadly the Muslim Americans and Muslim New Yorkers, more specifically, portrayed as violent threats with terms like quote terrorist, terror sympathizer, jihadi, Islamist, radical Muslim, radical extremist Muslim, and many of these posts tied his Mamdani's Muslim identity to terrorism, echoing these 20 years of post 9/11 tropes that cast this Muslim political participation as a national security risk. And this particular subset of posts with this terrorist labeling generated almost 880 million views. Um, and yet, despite this tidal wave of Islamophobic content, Mamdani still won because and nearly a million New Yorkers voted for him. And that outcome is also very important to emphasize here, because it shows that communities are not always swayed by these fear-based narratives, and that structural Islamophobia can always be challenged at the ballot box. But what struck us the most in the data was how effortless it has kind of become to mobilize the coded language of terrorism to attack Muslim political participation. And these were not fringe accounts or people. They included members of Congress, major influencers who have access to the White House, to President Trump himself, and media personalities, and these coordinated networks of far-right extremists in U.S. and abroad. All of those, they engaged in this narrative work, and they understand the power of word terrorist in the American imagination. And when it is labeled at someone, it collapses that person's entire identity into this single idea, and that is danger. So it eliminates that need to debate their ideas or engage with their constituency, and it just puts the entire community under this one umbrella of being a suspect. And this is the afterlife of course, the post 9/11 counterterrorism era, and the word terrorist still carries this enormous symbolic weight. So I think counterterrorism provides this vocabulary, and in this particular context, Islamophobia provides that emotional charge. And I think together they continue to shape who gets to identify as an American and who gets to participate in American democracy on equal terms, I think.
Yeah, thank you for that. And I think, pairing those two ideas together is really helpful for thinking about the next phase, which is sort of applying how these frameworks are playing out in terms of actual targeting through criminalization and prosecution and other forms of quashing dissent. But I think the kind of cultural force of the label of terrorism is relevant to also to what extent there is pushback on that kind of use of the criminal law in this effort to supposedly go after so people who are labeled terrorists, right? That social and cultural currency still of feeling comfortable labeling people a terrorist for their political ideas is relevant to the critique or lack thereof in these kinds of more assertive and aggressive uses of the criminal law and of state power. So, Azadeh, I think it would be nice to start with you and some of the domestic context for how this has played out recently. And so you, in your article that we posted earlier in the chat, detail the history of using counterterrorism charges in the US, in particular to target Palestinian organizations federally and to target protest movements locally. So can you tell us a little bit more about that dual history? And importantly, you show that this is not a historical relic, right? That this is not something that just happened 20 years ago, but that there are ongoing cases where people are fighting terrorism charges for community organizing and protest-related activities. How have these material support statutes and other counterterrorism charges been weaponized against nonprofits, charities, protest movements? Can you give us some examples?
Sure. So while domestic counterterrorism regulations are similar across countries, the exact definitions, the scope, and due process rights afforded to residents vary, sometimes drastically from one country to another. However, the overall impact of counterterrorism laws on social justice movements is similar. There are numerous examples from around the globe of counterterrorism measures impacting civil society and, by extension, social justice movements. Even before the war on terror and the subsequent globalization of counterterrorism frameworks, US counterterrorism laws were created, adapted, or weaponized in response to the Palestinian liberation movement. And this targeting only increased amidst the war on terror, with numerous Palestinian activists prosecuted under material support statutes. One of the most well-known of these prosecutions is that of the Holy Land Foundation and its leaders. Shortly after September 11, US prosecutors employed Section 2339B to target the foundation, a US nonprofit focused on providing humanitarian aid to Palestine, among other countries. The foundation and its leaders were charged with providing humanitarian aid to charity councils in the occupied Palestinian territories. The prosecution argued that these councils were affiliated with Hamas, which is designated by the Secretary of State as a foreign terrorist organization. In doing so, the US government applied Section 2339B based on the assertion that an intermediary organization, in this case the Holy Land Foundation, was affiliated with a foreign terrorist organization. The councils themselves were not designated as foreign terrorist organizations. The US government simultaneously provided aid through the same councils, and notably continued to do so even after the Holy Land Foundation prosecutions. Despite this, the Bush administration lauded the shuttering of the Holy Land Foundation as a victory in the early stages of the so-called war on terror. Concerningly, the Holy Land Foundation prosecution relied in part on questionable foreign intelligence from Israel. The weaponization of material support statutes against Palestinian organizations has a chilling effect on political and religious activity, because the statute applies to a wide range of activities and to organizations that are not directly designated as foreign terrorist organizations. Many activists have self-censored or felt compelled to seek legal advice, to avoid the risk of prosecution, reputational harm, and civil litigation before they participate in conferences, projects, or other expressive activities. Even mere allegations of providing material support to a foreign terrorist organization without any corresponding criminal prosecution have been weaponized against human rights organizations. These efforts include campaigns calling for a Department of Justice to investigate pro-Palestinian groups, with one organization even claiming that the Black Lives Matter protests were linked to so-called terrorist organizations. Calls for material support investigations into pro-Palestine activists amidst Israel's genocide of Palestinians is just the latest example of counterterrorism statutes being used as a political tool against social justice organizers in the US. Additionally, Section 2339B, which has an extraterritorial component, has presented significant barriers to international humanitarian work as smaller nonprofit organizations struggle to access funding amidst burdensome requirements intended to shield funders from liability. As these examples demonstrate, unsupported allegations alone of ties to terrorism have significant consequences for organizations and have been effective mechanisms for governments to suppress dissenting voices. In the US and other countries, such allegations trigger consequences as severe as restrictions on freedom of expression and diminished privacy. In the US, there is growing concern that the state domestic terrorism statutes will routinely be used to criminalize protests also. The Defend the Atlanta Forest movement was a loosely connected network of environmental and abolitionist organizers who opposed the construction of the proposed Atlanta Public Safety Foundation, referred to as Cop City. The proposed facility, which is up and running as of April 2025, unfortunately, would be construed in the Wilani Forest and is designed to be a so-called state-of-the-art police training facility that includes a mock village and helicopter pad. Activists have been opposed to the project since its inception due to its expansion of militarized policing and environmental impacts on the Wilani Forest, and began occupying the forest in late 2021. In response to this resistance, state repression began to escalate in December 2022, including through violence, with Manuel Esteban Poes Terán, an activist known as Tortuguita, killed by the police in January 2023 during a militarized raid on the Defend the Atlanta Forest encampment. Police shot Tortuguita 57 times. Shortly after, the Georgia Attorney General's office began pursuing domestic terrorism charges against arrested protesters. These charges, which carry heightened sentences, were applied to acts such as vandalism, and individuals were arrested based on thin evidence like their muddy shoes. Some protesters were seemingly arrested based on evidence unconnected to any wrongdoing, including merely having the number for the Atlanta Solidarity Fund, a bail fund active in the region, written on their bodies. The Georgia state government's decision to pursue domestic terrorism charges indicates that the prosecutions were intended to deter similar protest activity. The use of such domestic terrorism charges gives cause for concern that Georgia or other states will leverage similar laws to criminalize social justice movements in the future. In addition to protesters being targeted with expansive domestic terrorism charges, the state of Georgia also arrested 3 officers of the Atlanta Solidarity Fund, a bail fund affiliated with the Network for Stronger Communities nonprofit, which provided support to the Stop Cop City movement. On May 31, 2023, an Atlanta Police Department SWAT team raided the house of these individuals and arrested them for alleged charity fraud and money laundering. These charges were particularly concerning because bail funds have historically been valuable tools for social justice movements. Targeting bail funds has been identified as a long-standing tactic of repression. These arrests were explicitly connected to the broader movement. Arrest warrants alleged that the Atlanta Solidarity Fund was channeling money to defend the Atlanta forest. And these arrests will likely have an impact on political organizing and mutual aid. It is unusual for SWAT teams to be involved in cases of charity fraud. In addition, the state had an alternative since charity fraud complaints can be directed to the Secretary of State's Charities Division, since the Secretary has a statutory authority to launch a full investigation. The arrest could have been avoided, but there likely was a political motive behind the arrest because they occurred just days before the Atlanta City Council voted on funding for the facility's construction. The 3 Atlanta Solidarity Fund officers, along with numerous protesters, were later indicted under the Georgia Racketeer Influence and Corrupt Organizations Act, more commonly known as RICO. In part, these charges appear to target mutual aid, an essential component of many successful political and civil rights movements. Indeed, the indictment claims that mutual aid is a quote, term popularized by anarchists to describe individuals who exchange goods and services to assist other individuals in society without governmental intervention. The mutual aid efforts being targeted include transfers of relatively small amounts of money. The indictment also included 15 counts of money laundering against the members of the Atlanta Solidarity Fund. The transactions included items such as forest tools and forest kitchen materials. The indictments were expected but represent a dangerous precedent for protest movements to be prosecuted as one criminal enterprise. The indictments have caused concern among many activists that participation in future protests could be linked to current domestic terrorism and RICO prosecutions, exposing protesters to significant criminal liability. While the RICO charges against the Atlanta Solidarity Fund and others were dismissed by a judge in September 2025, protesters, as well as the National Lawyers Guild legal observer, are still facing domestic terrorism charges.
Thank you for that. And I dropped a couple of resources in the chat, which I hope wasn't too distracting to Azadeh as she was speaking. But just for folks to look at the indictment as it was originally constituted, folks at Interrupting Criminalization did an annotated version of the indictment, which I think is really helpful. And then I also dropped a link to an article on the criminalization of solidarity across time and in other kinds of labor organizing. And as Azadeh just mentioned, the money laundering charges were ultimately dropped, and also the RICO charges have currently been dismissed out of the case, although those may come back. We'll see. But I think the longer history here, right, suggests that these kinds of practices are not new, but also being used more often, and that there is fear that they may be used in contexts that are newer in terms of the lack of actual any kind of criminal activity, and this being really a political weapon. And to that end, I'm wondering, Raqib, if you can kind of pull us into an international context and talk about the way that you've both done research about the Indian government's crackdown on Muslim and human rights organizations in Kashmir. And so how are counterterrorism initiatives being used in those contexts? Are they connected to broader political campaigns and mobilizations around quieting dissent? And what kinds of tactics are being used by the state as part of this effort?
Well, building on Azadeh's point, and what we are seeing in India, specifically in Kashmir, is that the counterterrorism has become the primary instrument that state uses to suppress dissent and govern the minoritized populations, and they're often used preemptively to criminalize political expression itself. And in India, for example, these counterterrorism frameworks are embodied in draconian laws like the Unlawful Activities Prevention Act, the UAPA, the National Safety Act that gives authorities the power to detain people without formal charges for up to 12 months, and the Public Safety Act, the draconian law mostly used in Kashmir, which allows for detention for up to 2 years without a charge or trial on the purported presumption that they may in future commit an act of violence. And this law has been extensively used in Kashmir to silence dissent. And on paper, these laws are meant to deal with quote unquote terrorism, but in reality, they are designed so broadly and enforced so selectively that they have become tools to criminalize political dissent and suppress entire communities. Under UAPA, for example, the state does not even need to produce evidence of a violent act, mere association or speech or journalism that challenges the government can be framed as a quote terrorist activity or being an anti-national. So the intent here is to make the process a punishment, because we have repeatedly seen people being jailed for years altogether without trial, just under the pretext of preventing terrorism. And in Kashmir, this has been a very defining reality for decades altogether. And since 2019, when India revoked Kashmir's semi-autonomous status, almost any form of speech or civic activity can be folded into what authorities call a terror ecosystem, or for journalists specifically, they use this term called narrative terrorism. And journalists have been charged under UAPA simply for reporting. My friend and colleague Irfan Maraj, he was arrested in March 2023 and continues to be in jail without trial. And human rights defenders like Khurram Pervez, he has been imprisoned, been in prison since November 2021. and um, and uh, and there is and the unfortunate reality is that there is no comprehensive publicly available data on how many cases the government has filed under the UAPA, whether in Kashmir or more broadly throughout India. And what we do see come in fragments, often in scattered replies in Parliament, where members of Parliament question the Home Ministry, and in one such response revealed that between 2018 and 2022, almost 8,947 cases were filed under the draconian UAPA law, with more than 75% of all these UAPA cases in 2022, and this data is until 2022, coming from Jammu and Kashmir only, 75% of cases. And what is striking now is how these tactics have spread nationwide. Muslim organizations in mainland India, student groups, protesters who have led movements against discriminatory laws like the Citizenship Amendment Act, and even humanitarian non-profit organizations branded as terrorist and anti-national. Right now, we have activists like Umar Khalid, Sharjil Umam, Gulfisha Fatima, Miran Haider, Khalid Safi, very prominent student activists, in jail for nearly 5 years without bail, and all jailed under the draconian UAP. And in these cases, the long-standing legal principle has been that bail is the rule and jail is the exception. But in this particular case, and many other cases that involves Muslims, journalists, critics of this government or Hindu nationalism, this principle has been effectively reversed, where jail has become the rule and bail the exception. And alongside UAPA, the government has also weaponized the Foreign Contribution Regulation Act and the Prevention of Money Laundering Act. In fact, this one Amnesty International report in 2023 noted that Indian authorities have exploited the recommendations of the Financial Action Task Force, which is an international body focused on terrorism financing and money laundering. They have used these recommendations to justify draconian laws against the civil society organizations and human rights defenders. So the methods of repression here are broad, but you can see a lot of similarities between what Azadeh mentioned before and what we are seeing in Kashmir, in India, and even in Pakistan for that matter. I'll stop there.
Thank you for that. I'm going to drop a couple more resources in the chat, but did share some about some of the names, specific names you've mentioned. But Azadeh, I want to offer you a chance to also speak to your research about the same kinds of forces in Kashmir, if there's anything that you want to add before we move on.
I think I'll focus on Palestine, given that there's a lot to talk
Yeah,
about.
there's a lot to cover. So why don't you give us some of that about the repression experienced against Palestinian organizers within Israel and Palestine?
Sure. So the Israeli government has passed several laws aimed at limiting or cutting off funding for Palestinian civil rights and human rights organizations. For instance, in June 2016, Israel's parliament passed the Combating Terrorism law, which authorizes the Minister of Defense to designate an organization as a so-called terrorist organization. Once an organization is labeled with this title, the government may seize its organizational assets and prevent the organization from operating. Under the law, designations are initially temporary, giving organizations time to respond with written arguments for review by an advisory committee. However, the government may withhold confidential information relevant to the designation, as such organizations may not have full access to the evidence against them. UN experts have expressed concern that the provisions of the law that define terrorist act and terrorist organizations are vague and may be overbroad, susceptible to arbitrary enforcement. The Israeli government has used the law to stifle Palestinian human rights advocacy by designating human rights organizations as so-called terrorist organizations, or alternatively, by claiming that these organizations were somehow supporting terrorism. The connections between US statutes and Israel's designation of so-called terrorist groups also heightens concerns about the misuse of the combating terrorism law. In October 2021, the Israeli government used the law to designate 6 Palestinian human rights organizations as so-called terrorist organizations without evidence, claiming that they were financing the Popular Front for the Liberation of Palestine. A year later, in November 2022, the Israeli government targeted many of the same organizations in a pre-dawn raid in which armed forces issued military orders for the organizations to close and welded their doors shut. Affiliated staff and supporters of these organizations were also reportedly subject to reprisals, including deportation, travel bans, and digital surveillance. Evidence suggests that the US may have also added at least 2 individuals affiliated with these organizations to a no-fly list and prevented them from traveling to the US for human rights work. All these organizations have decades-long relationships with UN bodies and are widely regarded by experts and advocates as reputable human rights defenders. These organizations also have varied missions, though they all support Palestinian human rights. For example, the Bisson Center for Research and Development focuses on economic and sociology research topics ranging from global warming to Israel's occupation, while Ad-Damir provides legal support to Palestinian prisoners and those subjected to administrative detention, which is basically indefinite detention of Palestinians in Israeli jails. Numerous experts denounced the decision to designate these organizations as terrorist organizations. Shortly after the designation, reports emerged indicating that the decision was part of a years-long campaign by Israel to convince European donors to stop funding Palestinian organizations critical of Israel. For instance, Israel has previously failed to convince European governments to restrict funding by circulating a dossier prepared by Shin Bet, Israel's internal security force. Israel's designation of these organizations as terrorist organizations, much like the United States' designation of foreign terrorist organizations, had an undeniable impact on humanitarian efforts. Following the October 2021 designations, the Dutch government ended its financial support for the Union of Agriculture work committees, despite finding no evidence that the organization was involved in terrorism. Following similar allegations that pro-Palestinian civil rights organizations were linked to terrorism in November 2023, several European countries took measures to suspend or restrict funding to these organizations, even though the European Commission announced that, quote, no evidence has been found to date that money has been diverted for unintended purposes. The Commission still imposed additional restrictions on funding as well. And the connections between the US material support statutes and Israel designation of Palestinian organizations as so-called terrorists is particularly relevant given the downstream impacts of the Israeli government's targeting of Palestinian groups. So, case in point, in June 2025, the US government imposed sanctions on one of the organizations targeted by Israel, on the Ad-Damir Prisoner Support and Human Rights Association, a Palestinian human rights organization that represents Palestinian political prisoners in Israeli jails, that has participated extensively in efforts to hold Israel accountable in the International Criminal Court and other international bodies. This came after years of ongoing designations, sanctions, and other coercive measures applied to Palestinian organizations, leaders, and movements in order to criminalize their activities and subject those involved to persecution, surveillance, and economic coercion. In September, the US government also imposed sanctions on Al-Haq, another organization previously targeted by Israel, and two other Palestinian human rights organizations that were similarly involved in holding Israel accountable for the ongoing genocide targeting the Palestinian people.
Thank you for detailing those very challenging examples. And I've tried to drop in some of the kind of sources to support that if folks want to read more about those moments. We have 20 minutes left in our event and 4 excellent questions already queued up in the Q&A. So I'm going to ask one more question, which is hopefully a bit of hope for us to then move into the Q&A portion of the event. So you both have done work tracking and supporting social movements through these struggles and against state targeting. And although we've laid out some unique contexts, I imagine there are common threads across these contexts where people are banding together and finding ways to build power and fight back. So I'm hoping you can share some practical tips for successful cross-movement and cross-border resistance. And what are your long-term hopes for growing awareness of how these counterterrorism frameworks affect dissenting or marginalized groups? Let's start with Raqib and then go to Azadeh.
Well, I think I wish we had more time to talk about the international, the South Asian perspective on the weaponization of counterterrorism frameworks. But and 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 one thing that is pretty clear from what we discussed so far is that we have the same architecture of surveillance, criminalization of dissent, this preemptive detention, and this framing of entire communities as threats, and we have seen this very similar logic followed in different contexts. So I think resistance also has to be connected in some ways, and one practical lesson that I have learned is that movements cannot fight counterterrorism frameworks in isolation, because states usually benefit when struggles are siloed. And I think what has been very effective and most effective is when communities and different social justice movements share concrete strategies with each other, whether it comes to documenting abuses that we have been, for example, doing at Hindutva Watch for almost 5 years now. We have enormous data set of hate crimes, hate speeches, and then also the weaponization of these counterterrorism frameworks to target civil society and social justice movements. And it also comes down to different strategies on protecting digital communications on responding when activists or journalists are arrested, and how to support the families of those who are detained, and also how to build international pressure before these cases disappear into years of pre-trial detention, as I mentioned in the context of Kashmir and India. And I think when Kashmiri journalists speak with Palestinian journalists, or when US or organizers in US or Atlanta for that matter learn from South Asian human rights groups, there is that immediate recognition, because people understand each other's fears and also each other's tools that they have been using to mitigate some of these harms perpetuated by these different counterterrorism frameworks within their respective contexts. And these cross-border exchanges also help movements name what is happening more directly and clearly, and makes it harder for governments to isolate and stigmatize the human rights groups. And I think my long-term hope is that these connection force a shift in how the public understands counterterrorism, because as long as these laws are seen as kind of neutral security tools, they will continue to keep expanding. But when people recognize that these frameworks have become a mechanism for governing the minoritized populations and silencing dissent, it becomes possible to challenge the legitimacy of this entire framework. So, I think what also gives me hope is that despite this enormous pressure from arrest of activists and banning of organizations, and in fact, yesterday there's a question in the Q&A. CARE was designated as a foreign terrorist organization in Texas. The hope that I have is that despite this enormous pressure, communities are continuing to organize, document, educate and aware, and resist forcefully. And when they build these connections across border, it becomes much harder for authoritarian governments to take the control of the narrative. And that, I think, is the most powerful form of protection that we have. I'll stop there.
Azadeh, go ahead.
Thank you so much. So understanding the connections and similarities between systems of repression is key to strengthening international cross-movement solidarity. The proliferation of surveillance infrastructure and the rise of cross-border training and tactic sharing programs, such as the Georgia International Law Enforcement Exchange, GILI, which I should say is one of a lot of different police exchange programs between local and state law enforcement and Israel, where, for example, police from Atlanta is sent to Israel to learn better, and I mean more repressive tactics of repression, as if they needed more training in that aspect. And so there's a movement to try to basically stop sending of police to Israel. These are of paramount concern were placed within the broader scope of international counterterrorism frameworks. There are already numerous points of connection between countries' employment of counterterrorism laws to stifle dissent, many of which have already been recognized. For example, activists have discovered increasing military and industrial links between India and Israel, from cross-border tactic sharing to sales of military technology. Additionally, military technology and weapons developed and manufactured in Israel, which are used to oppress Palestinians, have been linked to repressive state policies and to genocides in Bosnia, Rwanda, and Myanmar. So you have a situation where Israel is effectively an exporter of technologies of repression to various governments around the world. Elbit Systems, an Israeli weapons manufacturer, has supplied its products to numerous authoritarian governments and had its technology used for surveillance across the US's southern border. International human rights mechanisms may provide useful tools to draw attention to systematic government abuses. Numerous treaty bodies, such as the International Covenant on Civil and Political Rights, provide civil society organizations with opportunities to submit shadow reports documenting country conditions. Other treaties include provisions that allow for the submission of complaints to international treaty bodies. And in addition to formal processes, people's tribunals convened by organizers with jurors from around the world can be a powerful force for holding governments to account. Although these tribunals do not hold legal authority, evidence gathered during these tribunals has drawn international attention and later been used in an international criminal court case. The case, for example, the case against Duterte, currently pending in the International Criminal Court. I was part of a people's tribunal where basically the folks from the Philippines took the verdict that the jury in the People's Tribunal rendered to the International Criminal Court, and this was back in 2018. And I have no doubt that it was the accumulation of tactics like People's Tribunals that finally moved the International Criminal Court to go forward with the case against Duterte. Since the Russell Tribunal in 1967, which looked into the crimes of the US government in Vietnam, people's tribunals have been held to address rights violations in numerous countries, including Brazil, Mexico, and the Philippines. Following the issuance of the Muslim ban, Project South, along with numerous community partners, held the People's Tribunal. We called it the People versus the Muslim Ban on October 9, 2017. The tribunal found that the ban violated the First, Fifth, and 14th Amendment of the U.S. Constitution, as well as numerous international human rights standards. Although the Supreme Court later upheld the ban based on its third iteration, the tribunal highlighted the ban's harm and provided a space for community members to share how the ban had impacted their lives, families, and communities. In the face of state violence and repression, social movements must share information and learn resistance tactics from one another. And I want to put forward a pitch for our local to global webinar series. Every 3 or 4 months, Project South has a 1-hour webinar where we bring voices from the global South and also some folks from the US South and across the country, and we share tactics of resistance. We don't need to reinvent the wheel. People in many other countries have fight fascism. And so we can look to our comrades in the Philippines, in Brazil, and elsewhere to learn what they did in order to stand up to fascism and persist and be victorious. And activists can look to current and past movements as useful frameworks when anticipating threats and preparing for government repression. In combating the GILI program, the police exchange program in Georgia, also known as the deadly exchange program, for instance, activists have drawn on lessons learned from earlier efforts like the Stop Urban Shield movement in California. As more COP cities have been proposed in cities across the United States, organizers have also collaborated and shared tactics to prevent the construction of these training facilities. Such information sharing is vital to continued resistance. Governments understand the power of cross-movement solidarity. As Israel's genocide in Gaza began, the Indian government prevented Palestine solidarity protests in Indian-administered Kashmir in late 2023, where Kashmiris have often vocalized solidarity with Palestinians. No doubt, government officials were trying to prevent Kashmiris from drawing further connections between Palestine and Kashmir. As history demonstrates, cross-movement solidarity will only strengthen collective resistance to government repression.
Thank you for all of that, Azadeh. Raqib has one more offering he wants to make. Go ahead.
Right. Azadeh mentioned about the U.S. and specifically the Atlanta police and Israeli exchange program where police officials from Israel would come and learn tactics here. In the context of Kashmir a few years back, some Kashmiri officers did a very same training program with the FBI, and as part of that group, there was this one specific police officer who was involved in torturing some of my journalist colleagues 6 years back, and he played a very significant role in censoring and ensuring that any narrative on social media platforms, specifically X, back then Twitter, would be contrary to the dictates of the Indian government. So as a result, he started summoning common Twitter users, to his police station. He was head of the special operation group, which is again meant to deal with so-called terrorism in Kashmir. And then the second point about the Elbit systems. By the way, Elbit system have a joint venture with India's Adani Group, that is very close to Prime Minister Modi. And this joint venture in India produces military drones and other defense technologies, which are focused on surveillance, border control, and counterterrorism operations. And in fact, some of these bombs and drones that you saw being used during this genocidal war in Gaza were also manufactured in India, which a lot of people don't know. So just wanted to highlight those 2 points.
Thank you for that. In the interest of time, I'm going to move us into the questions, and we're going to allow each person to talk and ask their own question directly. So Aida Ashuri, would you like to start asking your question?
Hi, yes, thank you so much. And it's amazing to see another Iranian in this framework. Azadeh, thanks so much for doing this work. It's so rare to see, to be honest, us in this leftist field. Yeah, I'm very interested in how local prosecutors, I'm actually shamelessly running for city attorney in Los Angeles, and I'm a human rights activist and have a longstanding, activism in anti-war, and I know that there is a connection between what's happening right now in local Palestinian groups, and then the local prosecutors going after Palestinian activists in particular. And right now with the Olympics coming up in Los Angeles, I'm concerned about the increased presence of ICE and even the possibility of using terrorist laws against activists during that time. And I was wondering if you foresee that as a possibility, and how can we combat that as activists and possibly with local prosecutors? And again, thank you so much.
Thank you for your question.
Thank you so much, and salam. Thank you for the question. So it's great to hear about your work, and I think local prosecutors can use their power, their discretion, not to bring cases against Palestinian human rights organizers, against folks doing human rights work. I think in any situation we can see how can we use our power to advance human rights movements and not to crush human rights movements. And I think basically you can choose to not go after folks doing human rights work.
Thank you for that. Yes, doing nothing is always a tool in prosecutors' tool belts that we have to remind them about, I think. So thank you for that. Our next question comes from Zane McNeil. Zane, I'm going to allow you to talk so that you can unmute yourself.
Hi, y'all. Thank you so much. I had a handful of questions, so I'll try to just boil it down to two.
Pick your favorite, yeah.
My one, specifically, the first one is about, and we talked about this a little bit, but about how the Trump administration and the Heritage Foundation is trying to use the domestic terrorism apparatus to go after people who are, quote, have extremism on gender, and then also are considering creating a new designation specifically for trans people. And so I was interested in your thoughts on what specifically the risks are for trans folks right now, and we can expect the risks to be in the future. Thank you.
Thank you. Does one of you want to start?
Right. Well, thank you so much for the question. I think it's a really dangerous moment in the US right now, especially in the past couple of months. Trump and right-wing forces have made it very clear that they're going to go after progressive movements and organizations, and the left, as defined broadly and obviously in the directive that Trump issued, they made it very clear that they're going to criminalize fighting against fascism. And so they have already designated several groups as foreign terrorist organizations, etc. And so we have to keep monitoring what they're attempting to do, and then continue to employ tactics of resistance to the state surveillance and the basically counterterrorism strategies.
Thank you for that. Anything to add, Raqib?
No, I think I can speak from the perspective of my organization. We do track these narratives and conversations across different social media platforms, and definitely we have seen this rising anti-trans rhetoric in major across different social media platforms. And I think this state level criminalization as well, and this rhetoric coming from this administration, I think we should expect these risks to increase and not decline in near future. And considering that there is this a lot of growing resentment among people about the failure in delivering a lot of on these different promises, campaign promises, and usually throughout history we have seen they always kind of look for outgroup victims to as perfect targets to distract. And as we saw yesterday, and as we have been seeing lately, where immigrants, refugees, people of color are being repeatedly targeted to just distract from these different policy failures. So I think In this particular context as well, the risks are quite, on the upper side, and again, it will continue to increase as we see things as they are right now.
And if I can just add,
Yes, go ahead.
yeah, I mean, I think we should all also be vigilant about what is happening in the states. I know the Georgia legislative session will begin in January. And so, we should obviously pay attention to what type of measures, additional, surveillance and possibly criminalization measures are going to be introduced in the Georgia legislative session. Oftentimes, these laws are basically copycat. And so this relates also to the Texas governor going after CARE. Obviously, this is not a power that the governor of Texas or any other state has. So this is purely a publicity stunt. And so, it needs to be treated as such. However, we should also pay more attention about what they're doing in the state legislature, because as we saw in Georgia, a lot of times the laws that they actually pass in the state legislatures do have actual impact in criminalizing protest activity, as they did with the Stop Cop City movement.
Yeah, thank you for that. And I'm going to jump off from that point to allow our last questioner to ask their question. This will be our last question of the event. Bana Wardi, if you'd like to ask your question. And I think to your point, Azadeh, about you've already answered one of these questions, which is that the governor doesn't actually legally have the power to make this designation, right? But there are other components embedded in this question. So, Ban, go ahead and ask your full question, if you're able to unmute. Okay, perhaps stepped away. So in that case, I'm going to ask the remainder of the question for everyone out loud. Do these state level actions provide any lawful basis for freezing bank accounts, investigating supporters, or pursuing donors and volunteers for criminal or civil liability? And to me, this also connects to your work, Raqib, more broadly about sort of the chilling effect of this kind of a designation on speech, on online activity, on other related organizing. So I wonder if you could all talk about both sort of like the actual legal ramifications for people on staff, for donors, but also for kind of the work of those organizations and the movements more broadly. Raqib, you want to kick us off?
Yeah, I think I can jump in. As Azadeh mentioned, that there, in fact, when yesterday the press release came out, I was just reading throughout whether he has authority. I'm not a legal expert, so of course he does not have any authority to designate a domestic organization as a foreign terrorist group, because that power exclusively rests with the U.S. Secretary of State. And I don't think that this state level label can be used to freeze bank accounts or other things that were mentioned in the question. But I think the state might try to, and again, it's a publicity stunt, and it's just a funny banter on X you can see between CARE and the governor. So the state might try to restrict state contracts or grants, which I think they don't give any, or even if they have given, they might have stopped altogether. But this literally has no lawful basis to trigger, any federal criminal penalties. But the risk here is that, this ban, that could be used as a pretext to invoke the broader, this designation at the federal level. And that is the push right now that we are seeing within the MAGA far right sphere, that, hey, Texas did it, let's do it federally. So I think that would definitely be used as a push towards the federal government to designate CARE as a foreign terrorist organization.
Yeah. Anything to add, Azadeh?
Right. And as Raqib mentioned, also just I think the bigger issue here is the danger to free speech and people self-censoring and not going forward with events and not going forward with projects, and fearing expressing themselves freely on social media or otherwise. And I think that is definitely an issue that we should all be aware of. And to the extent that folks aren't in immediate danger of prosecution or being targeted, I would encourage all of us to continue to speak out, because as history shows us, fascist regimes thrive on fear tactics and scapegoating and keeping all of us in isolation and continued state of terror.
Thank you for that call to action, and also thank you for actualizing for us what it looks like here to be able to speak out and offer your perspectives. And we really appreciate you both lending your time to us and for sharing all of this wisdom and research and resources. As I mentioned, all of the stuff that's in the chat will be posted on our website and sent out when we post the video. Thank you both so much for your time today. We really appreciate it. And we're back with the last session of the series on December 3rd.
Thank you very much.
Thank you. Thank you for
Have a
having us.
wonderful evening, and thank
Thanks.
you for your work. Take good care, everybody.
Thanks. Bye-bye.
Goodbye.